be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSE Global, there is a link to the website in the description of this video. Thank you.
Hello, everyone, and welcome to today's webinar, First State Update 2021 Case Law Developments and Updates to Delaware LLC Act. My name is Monica Melendez, and I will be your moderator. Joining us today are Matthew O'Toole, Christopher Kelly, and Michael Maxwell of Potter Anderson and Corroon, LLP. And with that, let's welcome Matt, Chris, and Mike.
Monica, thank you. This is Matt O'Toole. I will say that my partners, Chris Kelly and Mike Maxwell, will be handling the bulk of today's presentation, and they are each well positioned to discuss their respective topics today. Each of them has a very active corporate and alternative entity practice. Chris appearing in the Delaware courts, including in Delaware LLC cases in front of the Court of Chancery, and Mike on the transactional side, including advice and opinions on LLC matters. Chris will address a few of the recent LLC decisions, and Mike will discuss this year's amendments to the Llc Act. I'll just note as a brief preface to their remarks that this year really does fall under the heading and proves the adage that the more things change, the more they stay the same. The pandemic has, as we were discussing just about exactly a year ago today when we did last year's version of this presentation, the pandemic has continued to upend prior ways of conducting business. While we all hope that we revert soon to something closer to pre-pandemic life, many changes that have been induced by the pandemic with respect to the practice of law and judicial proceedings are likely to stay with us for the duration, especially those that involve the use of remote communication technology. In addition, in 2021, the Chancery Court has seen some changes, including the departure of Chancellor Bouchard after 7 years, Chancellor McCormick assuming the helm of the court, and Vice Chancellor Will joining the court. The Delaware General Assembly also had many new faces this year, but with all of the changes, the Delaware courts continued to demonstrate their adaptability and remained exceedingly productive. And amendments to Delaware's business organization statutes, including the Llc Act, were enacted as in most years. So the forward progress of Delaware law has continued. Chris has 3 cases that he'll discuss. Interestingly, each one decided by one of the newer members of the Chancery Court. So with that, I'll turn things over to him. Chris.
Thanks, Matt. Good morning, everybody. Our first case today is the case of Feldman versus AS Roma. AS Roma, or I'll refer to at times as the club, is an Italian professional soccer club. In 2011, a group of American investors acquired control of the club, holding that controlling interest through a Delaware LLC. In 2019, that control group sought to sell the interest in the club, but when the COVID-19 pandemic hit Italy in early 2020, the sale process stalled, and the controlling members sought additional investment from members to sustain it. Plaintiffs, who were minority members of the club, declined to make any additional investment. Instead, these minority members brought suit in the Delaware Court of Chancery, asserting a variety of claims challenging the control group's actions taken in response to the pandemic. By way of background, to sustain the company in recent years, some members provided loans to the company, which I'll refer to as the existing loans. In or around late 2019, the company engaged a financial advisor to seek a strategic transaction to sell the company's controlling interest in the club and provide an exit for the company's investors. Numerous potential bidders were identified, ultimately resulting in a prospective buyer being given exclusivity. Following due diligence and entry of a letter of intent, the company and the bidder engaged in negotiations on a definitive transaction agreement beginning in December 2019. Soon thereafter, however, in February of 2020, the COVID-19 pandemic hit. All Italian sporting events were suspended, and the club was forced to implement a variety of cost-cutting measures. The sale process stalled. To meet the club's financial obligations, the company's investor committee proposed a preferred equity offering available to all members to attempt to raise funds via issuance of a new class of membership units, Class C units, which would have priority over the existing Class A and B units, as well as carry a liquidation preference. The company also sought to recapitalize the existing loans by exchanging them for Class C units. Each member of the company was given the right to participate on a pro rata basis in both the preferred equity offering and the recap. Any member that participated would not be diluted and would receive a pro rata amount of Class C units. In anticipation and to facilitate the preferred equity offering and recap, the company effected an amendment to the LLC agreement to facilitate the proposed transactions, including allowing the Class C units to be converted at the option of the holder into a Class A unit. The proposed transactions, however, did not achieve a sufficient level of member participation to meet the club's financing requirements, and the preferred equity offering and recap were abandoned. The company then sought alternative sources of financing. The company proposed to obtain a secured bridge loan from lenders led by its investment banker and new member loans, which I'll refer to as the 2020 member loans, which would be senior to the existing loans. Again, all members were offered their pro rata opportunity to participate in the loans, and in June 2020, the member loans closed with approximately 80% of existing members participating. Plaintiffs did not participate and instead filed suit. After plaintiffs filed their complaint in the Court of Chancery, the company entered into an agreement to sell its controlling interest in the club. The purchase price, along with the company's cash on hand, would enable the company to repay the bridge loan, transaction expenses, the 2020 member loans, and nearly all existing loans. In addition, if the company could implement an efficient winding up process, the company potentially would have been able to pay the balance of the existing loans and effect a small distribution to company members. Plaintiff's complaint challenged the 2020 member loans and the amendment to the LLC agreement. Plaintiff's claims, although varied, were generally confined to two issues: the disclosures made to members in connection with the 2020 member loans and the amendment, which remained from the abandoned preferred equity offering and recapitalization. Count one of their complaint alleged that the company's managing member breached the LLC agreement by approving the amendment and failing to disclose all material information to the unit holders in connection with the member loans. Count two alleged that the managing member breached its fiduciary duties to the company and the non-managing members in connection with the amendment. Count three alleged a corollary claim that the control group of investors breached their fiduciary duties as members of the investor committee regarding the amendment. Count four alleged that the managing member's controller aided and abetted the managing member's breach of fiduciary duties. And count five alleged that the control group were unjustly enriched by the rights granted to them under the amendment to the LLC agreement. Defendants moved to dismiss the complaint, which the court granted in its entirety. With regard to count one, the court found that the complaint did not state a disclosure claim against the managing member. The LLC agreement provided that the managing member had the same fiduciary duties as a corporate director. So fiduciary duties, unlike many other cases, in this case, fiduciary duties applied. The court explained that with regard to a request for stockholder action, which the court assumed was the case with respect to the member loans, Directors were under a duty to disclose fully and fairly all material facts within their control bearing on the request. The court found that the complaint did not identify any financial information that was lacking. Additionally, the court found that the managing member did not fail to disclose information concerning the prospective sale of the club because the complaint didn't allege any false or misleading information, but simply that the plaintiffs complained that they were entitled to a prediction of whether the sale would occur before a specific date, and the court rejected the notion that the managing member was required to play odds maker. With regard to counts 2 and 3, which challenged the abandoned preferred equity offering and recap and the related amendment, the court found that plaintiffs' claims relating to the preferred equity offering and recap failed to state a claim or presented justiciable controversy because plaintiffs failed to articulate any harm because the transactions were abandoned. And while the amendment to the LLC agreement was not rescinded, the court found its terms, which depended on consummation of the abandoned transactions, had no practical effect and therefore negated plaintiffs' claims of harm. And with regard to count 4, the court found that plaintiffs did not state a claim for aiding and abetting because the court had found that there was no underlying breach of fiduciary duty alleged. As for count 5, the court found that plaintiffs failed to state a claim for unjust enrichment against the control group of investors, given that the preferred equity offering and recap were abandoned, and as a result, no benefit or detriment accrued from the amendment alone. So that's the Feldman versus AS Roma case.
Chris, the result in this case, to my way of thinking, does not seem surprising, and I wonder if you can speak to that. And secondly, if there is a notable takeaway or more than one notable takeaway from this case, can you speak to that as well?
Sure. So I think, two things jump to mind. The first is, oftentimes, and the Delaware Llc Act specifically facilitates it, parties and drafters of LLC agreements take advantage of the statutory flexibility provided by Delaware law to modify or eliminate default fiduciary duties. And in this case, it was a bit, unusual in that fiduciary duties were not disclaimed, but rather were specifically provided that they applied. The second thing is, I don't think the result was all that surprising, given that the Court of Chancery typically does not second guess decisions of a board of directors, and particularly when a board is faced with extraordinary circumstances and needs to respond to something like a pandemic and the business struggles that arise from that. So not surprising was the result. And if fiduciary duties had been disclaimed, it may have been possible to avoid costly litigation.
Yeah, I guess, as you say, this case included, the LLC agreement in this case included a specific affirmative statement of the fiduciary duties that were owed. And clearly there is a litigation avoidance benefit to a blanket disclaimer of fiduciary duties. Of course, sometimes that's easier said than done to implement, and oftentimes there's a middle ground between the affirmative imposition of standard corporate type fiduciary duties on the one end of the spectrum, and on the other, a complete disclaimer of fiduciary duties. And there's plenty of litigation cases from the Court of Chancery that demonstrate that range of possible contractual arrangements. The only other thing I'll just note about this case, unless you have something else you wanted to add about it, is it's one of any number of cases that we've seen over the last 18 months or so where the pandemic played a leading role in the underlying facts.
Yep, agreed.
Okay.
So
why don't you move on? Thanks.
Turning to our next case, which is In Re Coinman LLC, that involved a dispute between two members of an LLC, one which I'll refer to and the court referred to as the sweat equity member, and the other the court referred to as the financial or financial capital member. The LLC was organized as a Delaware entity by two longtime friends in or around 2016 to conduct a Bitcoin mining firm. The sweat equity partner requested frequent cash infusions, and the financial member provided those funds when requested. The members conducted their business informally, disregarding the LLC agreement's formalities. As the financial member continued to make capital contributions, those contributions did not follow the operating agreement strictures, but the sweat equity member never objected and even acknowledged that his interest would be diluted as the financial member made more cash infusions. In 2017, the sweat equity member agreed that he had been diluted to below 5% equity, and he negotiated to have his equity increased and fixed at roughly 18%. To preserve that ownership percentage, the financial member agreed that his future cash infusions would be considered non-dilutive loans. The parties proceeded along that mutual understanding, and that the financial member would hold over 80% of the equity. The members then considered redomesticating the company to Puerto Rico. They converted the company to a Puerto Rican limited liability company in 2018. Consistent with not following the operating agreement's formalities, the two members did not conduct a formal vote or solicit written consents to effectuate that conversion. Nonetheless, the sweat equity member advocated for the conversion, and he affirmed his consent to it later on. The members' friendship then fell apart, and the financial member leveraged his majority interest to unilaterally amend the LLC agreement to remove the sweat equity member from his managerial role. The sweat equity member then filed suit in the Delaware Court of Chancery to challenge his dilution, the conversion of the company to a Puerto Rican entity, and his removal from management. He also requested an order dissolving the company. Following trial, the court held that the sweat equity member waived the LLC agreement's formalities for dilution and conversion, that he had acquiesced in the dilution and the conversion of the company, and was stopped from asserting that he controlled half of the company's equity and from challenging the redomestication of the company to Puerto Rico. The court concluded that the company's conversion to a Puerto Rican entity stripped it of statutory jurisdiction to declare the company's present managers or to order judicial dissolution under the Delaware Llc Act, reasoning that those statutory grants of jurisdiction under the Llc Act are limited to domestic entities. The court also concluded that it lacks subject matter jurisdiction to work in equitable dissolution of a Puerto Rican entity. Turning to the court's analysis, the court first found that based on equitable defenses of the financial member, that member established that the sweat equity member was diluted to 18% ownership and that the company had been converted to a Puerto Rican entity. The court observed that Delaware law regarding LLCs was contractarian in nature and explained in pertinent part that where the operating agreement does not expressly deem an action void for failure to obtain requisite organizational approvals, that the action will be voidable, not void, as the entity and its representatives could have carried out the action had the proper approvals been obtained. Such voidable breaches of LLC agreements, the court explained, are subject to equitable defenses such as waiver, estoppel, and latches. The court then found that the sweat equity member had waived, was stopped from invoking, and acquiesced in the dilution despite the operating agreement's dilution requirements. Among other reasons, the sweat equity member knew of the requirements never objected to the capital contributions not following those requirements, that the financial member continued to invest funds to fund the company while believing those funds were considered dilutive capital contributions, and the sweat equity member acknowledged his interest had been significantly diluted. The court found that the operating agreement's anti-waiver and integration clauses did not change that result because when applied to post-contract behavior, they do not prohibit the court's consideration of subsequent promises, communications, or modifications to the express agreement. The court noted that on the waiver issue, the law is clear that non-waiver clauses are not ironclad protections that preclude courts from holding a party responsible for post-contracting behavior, and therefore an anti-waiver provision in a contract does not have the unfettered power in all circumstances to supersede the doctrines of waiver and estoppel. The court next found that the conversion to a Puerto Rican entity was valid, reasoning that the conversion was a voidable act that could be cured in equity. The court explained that the financial member was a majority member as a result of the dilution and therefore could give member consent to conversion, which did. And while the Board of Managers did not formally authorize the conversion, that would be a voidable act subject to equitable defenses that the court already found applicable. The court noted that the sweat equity member was intimately involved in pursuing redomestication in Puerto Rico. Because the company became a Puerto Rican entity, the court found it lacked jurisdiction over the sweat equity member's claims that he was improperly removed as a manager and to dissolve the company either equitably or under statute under the Delaware Llc Act. The court reasoned that the Act carefully distinguishes between Delaware and non-Delaware limited liability companies, and that the plain language of sections 18.110 and 18.802 of the Act precluded the court from adjudicating those claims. The court found that well-settled legal principles also precluded it from dissolving a foreign entity in equity, reasoning that such actions implicate the internal affairs doctrine and the interests of the sovereign. The court concluded that Delaware's approach is consistent with the general rule advanced in other state and federal courts that only the courts of the jurisdiction under whose law the limited liability company is organized has capacity to order its dissolution. Because Coinman no longer existed under Delaware law, the court held it was divested of its power to equitably dissolve the company. So that's Coinman.
Chris, that's an interesting case. You mentioned in connection with the prior decision that you discussed, the AS Roma case, how careful contract drafting can serve as a potent litigation avoidance device, and this case certainly proves the advice that observation of those carefully drafted contract terms serves the same purpose. You can avoid litigation if you play by the rules as stated in the operating agreement. This is also, I think, an interesting case insofar as it demonstrates the reality of how LLCs operate very often in practice. That loosey-goosey, informal approach to formalities happens in reality all the time. And the case is also interesting to my way of thinking in demonstrating that sort of teasing out the nature of the statement that LLCs are contractarian in nature. It's often said in terms of Delaware alternative entity law that the LLC agreement or the partnership agreement will be enforced as written, and that in some ways sort of obscures the reality of what's meant by the statements that these entities are contractual in nature. The operating agreement of an LLC or the partnership agreement of a limited partnership, they're contracts, and enforcement of those contracts will be done in accordance with the terms of those contracts under Delaware law, but enforcement is subject to defenses, including equitable defenses as noted here: waiver, estoppel, acquiescence. So it's illuminating in that regard in terms of what we mean. This case is illuminating in terms of what we mean by statements to the effect that the entity is contractual in nature. The case is also helpful, I think, in his discussion of concepts of voidness, voidability, and ratification, in that it nicely foreshadows one of the statutory amendments that Mike is going to discuss in just a few minutes. So unless you have anything else to talk about in relation to coinment, why don't you turn to the next case that you have?
Yeah, just to cap off your point and the discussion in the case is, LLC agreements are contracts, and under Delaware law, going back, some time, contracts, despite their terms, don't necessarily or are not necessarily only can be amended by written agreement. That the conduct-based modifications and waivers may arise in unique situations.
Yeah, it was nice to see the Pepsi-Cola case cited in that decision. It's an important case, and it really proves the point that you're talking about.
So turning to our third and final case today, Howard Midstream. That involved a suit seeking dissolution of a Delaware LLC and a declaration under Section 18110 of the Act that purported terminations of the petitioners from their roles with the company was improper. The company was managed by a 6-member board of directors. In April of 2021, co-founders H and B began to disagree about how to run the company. On April 14, the company's board formed a special committee to consider, review, and evaluate certain executive employment and other personnel-related matters relating to the two co-founders. Thereafter, the special committee concluded that one of the co-founders, who I'll refer to again as B, should leave the company. On April 25, the other co-founder, H, and the special committee requested B's resignation as an officer, which would have triggered his automatic removal as a director. H and the special committee also requested that the CFO, who was also a director, as well as the company's general counsel, resign. B, the CFO, and the general counsel were unhappy, but they nevertheless expressed interest in negotiated departures that would allow both sides to move on. The separation negotiations between the two sides did not go well. The company's other in-house counsel provided advice to the special committee, which negotiated against the petitioners regarding the terms of their separations. According to the petitioners, the special committee and co-founder H purportedly told the petitioners that if they didn't accept the separation offers, they'd be terminated. On May 25th, co-founder B and the CFO called a special board meeting for May 27, intending to ask the company's board to direct them to return to work. On May 26, co-founder H and certain of the company's investors secretly entered into an agreement to terminate petitioners from their offices while securing certain financial and governance rights that favored co-founder H. At the May 27 board meeting, the board purported to remove petitioners from their roles. The petitioners alleged that they were ambushed by a secret alliance. The petitioners then filed a petition in the Delaware Court of Chancery on June 3rd, seeking dissolution of the company and a declaration that their purported terminations were improper. Petitioners thereafter moved to compel the company to produce certain documents that its counsel withheld on the basis of claims of attorney-client privilege and common interest privilege between the special committee and the company, particularly co-founder H and the in-house counsel that was not the general counsel. The challenge documents were created between the April 25th resignation request and the May 27th board meeting. The petitioners asserted that B and the CFO were entitled to the documents because they were directors of the company during that time. In response, the company and the defendants asserted that the petitioners could not access the privileged information because they were openly adverse to the company after the April 25th resignation request. The parties agreed that adversity was present after April 25th as far as separation negotiations were concerned, but the issue was one of how broadly that adversity should be construed. The court denied the petitioner's motion to compel. The court began its analysis by recognizing the general rule that a director's right to access company information is essentially unfettered in nature. That rule applies equally to LLCs and their managers. The court then turned to the three exceptions to the general rule as recognized in one of the leading cases on the subject, Talisman versus Friedman from 2013. The first exception, the court explained, applies when the director's information rights can be diminished by an ex-ante agreement among the contracting parties. Second, the board can form a special committee excluding a director, and that committee would be free to retain separate legal counsel, and its communications with that counsel would be properly protected. And third, privileged information can be withheld from a director once sufficient adversity exists between the director and the corporation, such that the director could no longer have a reasonable expectation that he was a client of the board's counsel. Here, there was no ex-ante agreement, and while the court found the special committee's formation relevant, the key issue as presented by the parties on the motion was the third limitation, whether known adversity existed on the matter beyond negotiations about their separation terms after the April 25th resignation request. For purposes of the third limitation, the court noted that adversity is assessed in view of the reasonableness of a director's own expectations. Adversity, the court explained, cannot be unilateral or without the director's knowledge. After considering the parties' submissions, the court denied the petitioner's motion. The court concluded that the petitioners were correct, that their adversity on separation negotiations did not create adversity on all matters, but the court found that adversity could not be viewed as narrowly as the petitioners argued. The court observed that the petitioners had retained litigation counsel by April 22nd, 3 days before the resignation request. Around the same time, the court observed that they were conferring with each other about potential litigation and that they even withheld documents from production during this time frame under the work product doctrine, indicating that they were prepared in anticipation of litigation. The court therefore held that after April 25th, obvious adversity existed between the petitioners on the one hand and co-founder H, the special committee, and the other company in-house counsel on the other hand. The court rejected the notion that the adversity was limited to the separation negotiations themselves. While the board's effort to remove the petitioners at the May 27th meeting, the court explained, was a secret, the court found that the parties' escalating hostility on removal was evident. The court found the second limitation, the formation of a special committee, supported that determination, and the court rejected the petitioner's argument that H's and the in-house counsel's inclusion in the committee's discussions constituted a privilege waiver, finding their involvement within the scope of the committee's mandate. And so that's the third and final case today.
Chris, the first two cases that you discussed, the outcomes in those decisions, in those cases, the court's decisions didn't seem surprising to me, and I would say this case falls into the same category. Would you agree with that?
I would. The typical rule or the general rule is that a company cannot withhold information on a claim of attorney-client privilege against one of its own directors, subject to the exceptions that were discussed in the case. And here, as the court explained, it seemed from those facts that there was sufficient adversity that supported the court's determination to deny the motion.
Yeah, I think it's a good reminder. You often hear the statement that the director's right to information is essentially unfettered, but that qualifier essentially does have meaning. In this case, sort of indicates one example of how that qualifier plays out. So at this point, I'll hand things over to Mike for a discussion of the 2021 amendments to the Delaware LLC Act. Mike?
Thanks, Matt. Good morning, everyone. So we'll now discuss the recent amendments to the Act. As Matt mentioned earlier, this year continued to be a bit of an unusual year because of the pandemic, but amendments continued to be adopted. The process continued on, and the amendments became effective on August 1st, 2021. So the amendments this year focused on issues such as ratification or waiver of void or voidable acts or transactions, which was alluded to in the CoinMint case, the rights of members to obtain information, clarification of some of those rights, as well as the delegation of authority by conflicted members or managers, and then some additional changes to the statutory public benefit LLC provisions. As we did last year, I'll briefly touch on the process for adopting the amendments to the Llc Act and some of the other alternative entity and corporate statutes. So the legislative process in Delaware relies on a public-private partnership between the Legislative Assembly and the Delaware Bar Association. Specifically, the entity statutes in Delaware are handled by the Corporate Council, and the LLC and related alternative entities amendments are proposed and reviewed by practitioners on a subcommittee of the Corporate Council section of the Delaware State Bar Association. As part of this process, we work with government agencies, such as the Delaware Secretary of State, to consider updates and amendments that they are requesting, along with issues that have arisen through the course of practice for the members of the drafting committee and their firms, and other issues that have arisen or come to the attention of the members of the committee. So the proposals are vetted and discussed over the course of the year, and once agreed upon, they're put into a bill format and submitted to the legislature for consideration. So with that background, let's go ahead and maybe get into the amendments that were adopted this year. So one of the amendments this year focuses on a new safe harbor provision for ratification or waiver of void or voidable acts and transactions. So these amendments provide a rule, what they do is they provide a safe harbor provision for ratification or waiver of void or voidable acts and transactions. And it provides a rule different from the rule applied in a few cases that you see listed there, CompoSecure and the Absalon Trust cases. We could add to that, not necessarily a rule different, well, maybe different, but an example that is also demonstrated in the CoinMint case, which we may discuss as well. In these cases, the Delaware courts applied the common law rule that acts or transactions that are determined to be void generally may not be ratified. And the Supreme Court has noted that the common law rule is that void acts are ultra vires and generally cannot be ratified, but voidable acts are acts falling within the power of a corporation, though not properly authorized, and are subject to equitable defenses. So just by way of background, in the CompoSecure case, the LLC in that case had entered into a sales agreement that triggered certain approval provisions under the LLC agreement for related party transactions. None of the formal approvals, however, were obtained in connection with the execution of the sales agreement. Nonetheless, after CompoSecure had signed the sales agreement, both parties initially treated it as a valid agreement and performed it in accordance with its terms. CompoSecure objected later to paying a commission in accordance with the sales agreement and brought suit seeking a declaration that the sales agreement was invalid and alleging that the sale agreement had not received the formal approvals required by the relevant related party provisions under the LLC agreement. After establishing that the sales agreement was executed without proper authorization, rendering it an improperly authorized contract, the Court of Chancery distinguished between void and voidable acts. And it stated that Void acts are those that an entity lacks the power or capacity to effectuate, while voidable acts are within the power or capacity of an entity, but were not properly authorized or effectuated by the representatives of the entity. The court went on to find that given the broad purposes set forth in the CompoSecure LLC agreement and the related authority that included the power to enter into contracts, and because of the related party provision recognizing the power of CompoSecure to enter into contracts, subject to the satisfaction of these certain procedural requirements, the Court of Chancery held that the CompoSecure had the authority to enter into the sales agreement and similar agreements. And so that the fact that the related party provision requirements had not been satisfied rendered the sales agreement voidable rather than void. And then the court then noted that the voidable acts can be validated by equitable defenses such as ratification and acquiescence, similar in some respects to the coinment discussion we had earlier. Because CompoSecure recognized the existence of the sales agreement, treated it as a valid and binding agreement, and accepted the benefits of the other party's performance under the agreement, the Chancery Court found that its conduct ratified the sales agreement. Now, the Delaware Supreme Court affirmed in part and reversed in part the decision by the Court of Chancery. The Supreme Court agreed with the Chancery Court's determination that even though CompoSecure did not obtain the required approvals to enter into the sales agreement, given that CompoSecure had the power to enter into the sales agreement with the proper approvals, the sales agreement was voidable rather than void. In addition, the Supreme Court agreed with the Court of Chancery that CompoSecure had implicitly ratified the sales agreement by accepting the benefit of the agreement and not disaffirming them until 6 months after it had been executed. The Supreme Court noted, however, that the Chancery Court failed to consider a provision of the LLC agreement pertaining to restricted activities, and this provision essentially stated that specific approvals were required for these certain restricted activities. I think it was a dollar threshold, if I remember correctly, and so the LLC agreement also provided that failure to obtain the required approvals meant that any action taken in contravention of that provision shall be void and of no force or effect whatsoever. So the Supreme Court stated that if the sales agreement was found to be a restricted activity under the LLC agreement, then it would be rendered void, and in contrast to being rendered voidable, it couldn't be ratified. So the Supreme Court, following the common law rule, again stated that voidable acts fall within the power and privileges of a company, can be ratified, while void acts can't. And so with that in mind, it remanded to the Court of Chancery the case for further proceedings. Absalom Trusts applied the rule in CompoSecure in connection with an assignment of a transfer of LLC interest, and the Court of Chancery determined that the transfer was rendered null and void by the express contractual terms of the LLC agreement, and as a result was incapable of being ratified. So you have this situation where you have voidable acts and void acts, and void acts, under the common law rules, can't be ratified. So a new subsection has been added to Section 18106 of the Act to provide a safe harbor procedure for ratifying acts or transactions that may be taken by or in respect of an LLC under the Act or an LLC agreement that are considered void or voidable, including waiving failures to comply with the requirements of an LLC agreement that make such acts and transactions void or voidable. So under this new provision, any act or transaction that's void or voidable, when taken, may be ratified or waived with respect to failures to comply with requirements of an LLC agreement that make such acts or transactions void or voidable. But it may be ratified by the persons whose approval would have been required under the LLC agreement for such act or transaction to be validly taken, or to amend the LLC agreement in a manner that would permit such act or transaction to be validly taken, in each case at the time of such ratification or waiver. So you don't have to go back and find the exact same people to consent or approve to ratify the action, with the caveat that if the void or voidable act was issuance or an actual assignment of LLC interest, those issued or assigned interests will not be counted in the calculation of the approval requirements for that ratification or waiver. So any act or transaction that's ratified with respect to such failure to comply, ratified or with respect, waived with respect to a failure to comply, is deemed to have been validly taken at the time of the act or transaction. So that's another benefit of having the statutory provision where the ratification relates back to the time that the action was deemed to have been taken. Now, there are also some notice requirements that come into play here. If an amendment to an LLC agreement, for example, to permit an action to be validly taken requires notice to members, managers, or other persons under the LLC agreement, then notice of ratification or waiver of such act is also required to be given to the same persons that are entitled to notice of an amendment or such an amendment. Now, notably, persons including managers and members of the LLC and anyone else claiming to be substantially and adversely affected by a ratification or waiver of a void or voidable act or transaction under the new safe harbor may apply to the Court of Chancery for a hearing on the validity and effectiveness of such ratification or waiver. The amendment expressly provides that harms which would have resulted if such act or transaction had been valid when taken, however, do not satisfy the threshold for application for review by the Court of Chancery.
Mike,
yeah.
Go ahead. I'm sorry to interrupt.
No, go ahead, Matt.
I was going to say that in the Coinment case that Chris discussed a few minutes ago, the case discussed the fact that the statutory conversion transaction was defectively authorized in the sense that formalities under the LLC agreement were not observed, and the transaction was voidable, and but it was upheld, and there was no mention of the transaction having been ratified in the Coinment situation. That transaction predated these amendments, but can you speak to the statutory amendments in light of or in the context of Coinment, and particularly the provision in the amendments that basically provides that they're non-exclusive in the sense that they don't preclude other valid means of ratification or waiver that might be effectuated?
Thanks, Matt. That's right. The Coinment case is interesting because the court did determine it was voidable, and I think that's because the majority members were deemed to have consented, which meant it was subject to equitable defenses, and so there are other ways, and the statute and the amendment specifically provides that it's not to be construed to limit the accomplishment of a ratification or waiver of a void or voidable act by other means permitted by law, which means, in this, for example, in the Coinment case where equitable defenses, waiver, and acquiescence applied, I think effectively ratified the voidable acts, given the conduct of the parties, going back to kind of the contract basis that how LLCs and limited partnerships and these alternative entities are treated. The other way that this was often accounted for, I think a lot of practitioners felt that you could amend an LLC agreement or partnership agreement or whatever it may be to, provide or ratify certain actions. And so the drafters of the amendment were careful not to override or limit the accomplishment of ratification or waiver in other means, by other means, I should say. But, what it does do is provides a safe harbor that allows us to, comply with the formal process, including, some of the questions that arise when you amend to ratify is, do you have to go back and find the old members, and who needs to actually consent? And some of those questions are, taken care of in this amendment by providing that those members who are currently, under the LLC agreement, able to approve a transaction or act or amend the agreement in accordance with the LLC agreement are the ones that can actually ratify the matter, and there's a safe harbor provision provided by that.
Yeah, you're right in sort of referring to it as a statutory safe harbor. It doesn't preclude other contractual means of essentially achieving the same result as we saw in Coinment, not just the waiver concept, but also estoppel and acquiescence. And I'll just note in regard to your reference to amendment of the operating agreement being viewed as a way to also accomplish the same goal. The underpinning for that position, I think, is that the statutory construct for amendments to an LLC agreement specifically contemplates that an amendment can relate back in time, and with that, it's viewed as a means of effectively blessing oversights that occurred at a previous time.
Yeah, that's right, and I fully agree with that view.
Okay. Well, I do think that that amendment is certainly an important amendment, and the other things that you'll be talking about are likewise worth discussion. But if there's a highlight, I think, of the 2021 amendments for practitioners, the ratification and waiver amendments that you just talked about in the statute are really important. And going back to what Chris talked about earlier, they're really important in terms of their potency for avoiding litigation, which is, as we all know, costly and time-consuming and otherwise problematic. So with that, Mike, I'll turn it back to you.
Thanks, Matt. So moving on, as Matt mentioned, probably the more substantive and important amendment was the ratification, the new ratification section. Moving on to some of the other changes this year, Section 18305G of the Act has been amended to clarify the rights of a member to obtain information for a stated purpose pursuant to the Act or an LLC agreement is limited to such information as is necessary and essential to achieve such purpose. So this stems from, in books and records cases with respect to Delaware corporations, Delaware courts have historically held that a stockholder's right to inspect a corporation's books and records is limited to information that is, quote, necessary and essential to the stockholder's stated purpose for such information. In a case, the Murphy case, the Delaware Supreme Court declined to apply such standard to a limited partner's request to inspect certain books and records of a Delaware limited partnership pursuant to a contractual inspection right. The Delaware Supreme Court reversed a Court of Chancery decision that limited partners were not entitled to certain books and records because the books and records were not necessary and essential to the purpose of valuing the limited partner's ownership stakes in the partnerships. And the Supreme Court had held that the limited partners were contractually entitled to the books and records under the governing partnership agreements without regard to whether they also would have been entitled to the documents under in the partnership statute 17305, which is substantially similar to 18305, or any showing that the documents were necessary and essential to the limited partner's stated purpose. And one of the key findings in that is that what was interesting, I guess, in that case was that the language in the partnership agreement effectively tracked the 17305 language, but did not say anything specific about that any requested documents must be necessary and essential to the stated purpose. So the court did not read in any kind of contractual standard there. So the current statute, the current act, to the extent that the current law is that a necessary and essential test does not apply by default to a member's right under 18305 to obtain information from an LLC for a purpose reasonably related to the member's interest as a member, or to a member's right under an LLC agreement to obtain information from an LLC for a stated purpose. The new first sentence of subsection G of section 18305 is intended to change such law. And the amendment's intended to really apply the standard of necessary and essential to a member's rights to books and records under the Act, as well as the right to obtain information pursuant to an LLC agreement.
So Mike, in light of what you were just discussing, particularly the Murphy case, is it fair to say that the amendment that you were just discussing, sort of adding or posing the necessary and essential standard in 18305, is it fair to say that that amendment, in a sense, is not really new, or it doesn't really represent a change?
That's right. I think it's not new in the sense that, well, first off, Murphy was a partnership case applied to limited partnerships, and so it's not necessarily binding on the LLCs in the LLC context. That said, because of similarity in the statutes and the courts look to the various alternative entity statutes in interpretation, I think the likelihood that it would apply is high. But so I think in that sense, yes, Murphy could possibly apply, but I think what the change is and what the amendment is intended to do is really revert back to what I think practitioners really thought should have been the results in the first place, which is that the necessary and essential, to the extent that there is a purpose is reasonably related to the member's interest, or there's a stated purpose in an LLC agreement, that any request has to be necessary and essential to that purpose. Now, with that said, there's if you don't have a stated purpose, or there's not some standard that says must be reasonably related to the member's interest in the company, and if you just insert into your LLC agreement an unfettered right to receive information, books and records, documents, other types of information, which was clarified also in the amendments. If you put that in there without any kind of stated purpose or qualifier, I think the result is likely still going to be similar to the Murphy case, that you have a contractual right to that information without requiring to provide a necessary and essential test.
Yeah, that's a good point. I was actually going to ask you about that. So if you had an information access right as stated in an LLC agreement that was divorced from any sort of proper purpose requirement, the necessary and essential test pursuant to this amendment would not be read in.
That's right. I think that's the result. Where that would go is it's not there's no stated purpose, there's no reasonably related standard, those types of things that are even in the new statutory language at the beginning of 18305G. So the necessary and essential would not likely be read into in that situation. And I think that's an example, as you see further down in that section where you talk about expanding or restricting the rights. I think that's an example of an expansion of the rights of a member to receive information. So again, just another warning or note for practitioners that they need to be careful in their drafting of LLC agreements, in particular information rights, to make sure that if the intent is to, in a books and records claim, to have a necessary and essential test read in, similar to what's done in the DGCL and 220 books and records cases, then there should be some kind of purpose, a standard that it's of purpose reasonably related to the member's interest, or some other stated purpose. To the extent that that's absent, then I think a court's going to read that as an expansion as permitted under the Act, and possibly give more unfettered access to the members.
And that's an interesting point, Mike. The ability to expand these rights probably was implicit before these amendments became into effect, but the amendments actually made clear, explicit, that expansion is a possibility.
That's
right.
With
that, why don't we move to your next topic, since we are running near to the end of our time.
Sure. So we'll quickly touch on a few additional amendments that were made here in 2021. So first is we're next going to talk about the delegation of rights, powers, and duties over matters where the principle of delegating such authorities conflict. And this really is in response to a line of cases, including the Wensky Bluebell Creameries case, where the court did not permit a conflicted principle in a GP, a general partner of a partnership, limited partnership, to delegate authority to a special litigation committee because the principal, in this case the general partner, was conflicted. So Section 18407 was amended to clarify that that there's going to be a rule different from the one applied in Llc should be applied, and really that I think in a lot of people's minds that the breadth and the broadness of the Llc Act, the flexibility of the Llc Act is being just confirmed and reaffirmed here. And really it provides that members and managers of an LLC may delegate their respective rights, powers, or duties regardless of whether the principal has a conflict of interest with respect to the matter for which such rights, powers, or duties are being delegated, and also provides that the persons to whom such rights are being delegated are not conflicted solely by reason of the conflict of the delegating principal. So in the Llc Bluebell case, the general partner, for example, would have been able to delegate authority to a special litigation committee to, look at the litigation and make a determination there. Similarly, the amendments make clear that any delegation may be made to a committee of one or more persons, so it doesn't just have to be delegation on a one-to-one basis.
Mike, this amendment is, I think, one of a series of revisions that have been made with respect to delegation the last few years that really differentiates alternative entity law from Delaware corporate law. And thank you for that discussion. I think that in light of the time, maybe we can turn things to Monica for a moment so she can provide the second CLE code, and then as time permits, maybe you can quickly hit the last segment of your presentation after that.
Sounds good.
Mike, in light of the tight time we have here, maybe you can briefly talk about the amendments for statutory public benefit LLCs, and then we can take a look at some questions that have come in.
Sure, and I'll be brief. I think for these amendments to the statutory public benefit LLC provisions really are, I think, clarifications and confirmations of certain things and maybe some cleanup changes. So 181201 of the Act, which pertains to the creation of a public benefit LLC, has been amended to really clarify that LLCs can be formed as public benefit LLCs from inception or can elect to become public benefit LLCs after formation. And if it's not formed as a public benefit LLC, it provides the standard for which it may become a public benefit LLC, which is essentially the manner specified in its LLC agreement or by amending its LLC agreement and certificate of formation to comply with the requirements of subchapter 12, which is the section subchapter of the Llc Act pertaining to public benefit LLCs. 181202A of the Act has been amended to provide that the public benefits to be promoted by a public benefit LLC must be set forth in the LLC agreement. Currently, only the certificate of formation is required to contain that information. Or I should say, currently prior to the amendment. So now the post-amendment, that must be in both the certificate of formation and the LLC agreement. And to the extent of a conflict between the certificate of formation and the LLC agreement regarding the public benefits to be promoted, the amendment requires that the LLC's governing agreement control as to anyone bound thereby. It also requires that in a case of such conflict, the LLC certificate of formation be promptly amended to resolve the conflict. And then 1202A was also amended to confirm that any provision in an LLC agreement or certificate of formation of a public benefit LLC that's inconsistent with subchapter 12 will not be effective to the extent of any such inconsistency. And then finally, 18123 of the Act, which previously required that certain actions taken by or on behalf of a public benefit LLC be approved by a supermajority vote of its members, has been repealed by the amendments, and then there were certain other sections that have been amended to really make conforming changes. And I think that wraps up the public benefit LLC.
Thanks, Mike. Monica, do we have time to address a few questions?
Yeah.
Okay. So a couple of questions came in relation to the ratification amendments, and they're very good questions. One deals with whether ratification is applicable to actions that predate the August 1, 2021 effective date of the amendments that Mike discussed. And secondly, can an LLC seek a declaratory judgment in regard to purported ratification? I'll say with respect, and certainly Chris and Mike can chime in if they have other thoughts or some view that's different from mine. With respect to the question about a declaratory judgment action, I think the answer is yes. There could be a declaratory judgment action subject to rightness standards. And with respect to ratification of acts that took place prior to the amendments becoming effective on August 1, I'll note a few things. First of all, the amendments, as Mike noted, by their terms are non-exclusive of other means by which a ratification or waiver can take place, witness the Coinmint case. The amendments do not include any explicit statement that they are prospectively applicable only. And finally, there is the statutory rule in 1811-06 of the statute, which is present likewise in parallel provisions in the Llc Act, to the effect that amendments apply to all LLCs, not just those that are formed after the amendments take effect, and all member and manager rights are subject to the reserved right of the state to amend the statute. There was a question, and maybe I'll let Chris address this, a question about, in the context of information access rights, does a company have to provide documents, in other words, forward copies, or just allow for an in-person inspection of documents, meaning that there might be travel involved and things of that nature? Chris, do you want to just address that from a litigator's perspective?
Sure. Frankly, I'm not aware of a case that's addressed the issue. I would say in every case I've ever had, even just demands that, don't lead to litigation, where documents where inspection is provided, the documents are just electronically provided. I don't think I've ever had a situation where there's been a physical inspection at the principal place of business of the company.
Yeah, thank you. There was a question that's, I think, a little bit beyond the scope of what we were talking about here, but just briefly to address it, the question was in relation to an Article 8 opt-in in the context of a single-member LLC, and my advice in that context would be, if there is no written LLC agreement, which is possible and permissible, but if you're trying to do an Article 8 opt-in to satisfy a lender's requirements, then I would do a written agreement for that purpose and include the opt-in in that opt-in language in that written agreement, and likewise in any certificate that evidences the LLC interest that presumably is going to be subject to a pledge. There was a question about whether under the delegation amendments, the delegating party must abstain from voting individually and withdraw or waive any right to do so. I think the answer to that is no, although it may very well be advisable in a particular context. And so I think that's all of the questions that we've received. Chris or Mike, do you want to add anything to the responses that we've provided?
No, this is Chris. Not on my end.
Hey, Matt. No, I don't have anything to add. On the delegation point, I guess I would agree with what you said. I don't think it's necessarily required, but it may be advisable depending on the circumstances and the context in which you find yourself.
Yeah, and certainly if it's done out of concern about conflicts, it would seem pretty clearly advisable. So,
Right.
So with that, Monica, we'll hand it over to you for the last word.
Thank you to everyone who joined us, and we hope to see you next time.